Sheriff Ozzie Knezovich talks with community leaders about issues in the public safety arena. Sponsored by River Ridge Hardware.
Folks, this is Sheriff Ozzie Knezovich with the Sheriff's Report. Hope you're having a good day today. If you remember, there was quite the controversy last year when the Washington State Legislature passed new police reform laws. And the legislature passed these laws and gave us in law enforcement about 2 months, and that's being generous, to figure out how to implement this. And they gave the AG and the Washington State Criminal Justice Training Commission a year to figure it out. And again, we were supposed to do it in 2 months. And sheriffs and chiefs from across the state began stepping up and saying these laws are very unclear. They're very dangerous to the public. And you know, what we got back from the people in the legislature, from the media, from the activists, was that we were just throwing a tantrum. We were misleading the public. We were telling people that, you know, all these wrong things about these new glorious police reform laws that had been passed. Well, this month, the Washington State Attorney General's office came out with their decision on House Bill 310, which contained many of the most egregious police reform bills and aspects of those bills, much of that surrounding the use of force. And it was an amazing read. It's 26 pages long. And if we can go to the first slide, that subtitle there kind of gives you an idea of what they thought about it. In light of this uncertainty, for the following reasons, we strongly urge the legislature to clarify its intent regarding the important issues listed inside House Bill 1310. Now, that's the AG's words, not mine. And we're going to cover a little bit more of that decision that they just published. But let's go to the next slide, because if you remember, the media, as true to the media's being, started being the propaganda arm for the legislature. This article by Crosscut, if you take a look at the subtitle there, a closer look at some of the concerned statements made by police chiefs and sheriffs. Next slide. In the first couple of paragraphs of the article, and you know, you take a look at that, especially the last line of that. As it states, while some of these statements contain elements of truth, others are misleading and leave out important context. And that's about what we were saying about what 1310 did to our ability to serve you, the public. Well, I can tell you that none of it was misleading, and it didn't leave out context. It just wasn't what the media and the activists who pushed these bills through the legislature and the activist legislators wanted you to hear. Next slide. One of the things that many of our legislators wanted you to believe was they contacted law enforcement about these laws. They contacted us, and we joined in on the crafting of these laws. That's not exactly true. Matter of fact, we were pretty much frozen out of that process, except for one organization, the Washington Fraternal Order of Police. And this is the one that the legislature, the media, quite frankly, even our local members of our legislature, Senator Billick, kept pointing to is they were here. They sat at the table. They sponsored these bills. Look, folks, that is not representative of the law enforcement in this state. It is not representative of the law enforcement leadership in this state. It is a police association that, quite frankly, sells goods to police officers. One of those goods they're hoping to be able to sell is malpractice insurance to law enforcement officers. Should our state legislature pass a law doing away with qualified immunity for your law enforcement? Qualified immunity, folks, is something that we have as law enforcement officers that gives us a little bit of protection in making split-second decisions on how to handle high stress, high crisis types of scenarios. And it does not, like the activists portray it, prevent us from being sued. We get sued often. Law enforcement officers get sued often. They want to convince you that they have to do away with qualified immunity in order to hold us higher accountable and be able to sue us if we do things wrong. That is a false statement. We can be sued right here, right now, happens all the time, but they want to take that one little bit of protection away from your police officers. Net result is going to be good luck recruiting police officers in the state of Washington, and good luck retaining them, keeping them working here. My agency alone, I talked to a group of 20. 90% of that 20 said they will leave the profession if that passes. And they're not joking. They're not bluffing. As, quote, as much as we love doing what we do, I will not subject my family's future to that uncertainty. Colorado did it. They're bleeding police officers out of that state. We need to think about what we're doing and who's supporting these things. Sure, the FOP is supporting this because it gives them a chance to earn money off of the very police officers they claim to represent. Qualified immunity is very important, folks. Here's another thing that our legislature did last year that wasn't really talked about. They changed the entire dynamic of the Criminal Justice Training Commission, the membership of that board, stripped law enforcement positions out of it, put activists in it, and they gave them full immunity in the decisions they're going to come down with, meaning they can't be sued. They have total immunity, ladies and gentlemen, and this is a bunch of activists that are going to make decisions about your law enforcement officers, certifications, and if they get to keep their jobs. I don't even have total immunity when I deal with labor issues or termination issues. I get sued for labor issues, and if I terminate somebody unjustly, I can be sued. This group, total immunity. And they get to ponder these situations for months on end while your law enforcement officers have split seconds to make a decision on how to save your life. And they want to take qualified immunity, meaning we have to actually qualify for that immunity, meaning we have to be shown that we did it right, we stayed within the laws, we stayed within the policies and procedures, we didn't violate your civil rights. If we do any of that, we get sued. But these people can violate your civil rights of a police officer. They can take your job away from you unjustly with full, total immunity. You tell me what's fair about that. But that's what your legislature did. And they did that with intent because they knew, as sheriff in chief, we can get sued for making such egregious actions. But they made sure these activists can do it with total immunity. So if we can go back to the slide, the representative of the FOP, I think he's the president or vice president, had this to say. It's unfortunate that some law enforcement are misrepresenting these laws. Well, none of it was misrepresented, folks. That is a direct misrepresentation. And him portraying himself as being representative of the law enforcement in this state is the biggest misrepresentation there is. Next slide. Sheriffs and chiefs from Eastern Washington came to Spokane Valley. We had a press conference. KXLY covered it. Next slide. And Senator Billig made the claim that he had talked to me about these reforms. No, we didn't talk about those reforms. He and I never had a conversation. Well, Sheriff, it says that you did. Here's how that went down. We'd been working steadily to ensure that the legislature didn't take the armored vehicles away from us that keep you safe. The Republicans that we were working with had it all worked out. Last minute, they changed the bill that we had in the Senate, and I was told, your only hope is to get a hold of Billig. So I had one of my staff administrator call the senator and say, hey, look, if this happens, it's going to cost the sheriff's office $500,000 to replace that armored vehicle. Now, is that a discussion? No, it was a statement. To his credit, Senator Billig was able to pull that back out of the bill, and we were able to keep our armor. But that's not a discussion. That wasn't anybody reaching out and asking an opinion. That was what you call a Hail Mary. We literally threw a Hail Mary trying to prevent them from taking a tool away that protects you. Next piece of that slide. But the senator goes right back to, one of the state's largest law enforcement organizations, the Fraternal Order of Police, actually supported both bills. Again, they are not representative of the law enforcement in this state. They are large, but many of the folks that belong to it because they simply buy their products. And not one of them is reflective of leadership in this state. So for that statement to keep getting thrown out, and it's being thrown out this year again, the FOP is actually sponsoring the bill to do away with qualified immunity in hopes of being able to sell malpractice insurance to police officers. A little conflict of interest, just a side note. That is not representative of police officers. And the legislature needs to stop saying it. And the media needs to stop saying it. And the FOP needs to stop representing themselves as being that voice. They are not our voice. They have never been our voice in the state of Washington. For sheriff and chiefs, that would be the WASPIC, Washington Association of Sheriffs and Chiefs. And for line level law enforcement in the state, it's WACOPS, Washington Chiefs and Police Organization. That's the main union in the state. Those are the ones that represent law enforcement, not the FOP. Next slide. So this is just a snapshot of the letter that the AG sent back to the legislature. They had basically 3 questions they wanted to answer. Next slide. But then they also pointed out it wasn't just those 3 questions that you, the legislature, wanted us to ask or answer concerning your own legislation. There were several other pieces that you wanted us to clarify. Next slide. And it's highlighted right here. This is just a section of what was presented to you. But I'll point out, we will address those questions after finishing your request of the first 3. And that's in reference to the other questions that were asked by representatives such as Skylar Rudd. Next slide. So, the AG started his explanation of 1310 like this. And that first bullet point up there kind of says it all. The answers to all your questions are extremely difficult. Does that sound like this was clear and understandable law that was passed last year? Or is that a prelude to this was really bad? Well, you can make that determination by the time we're done. The other bold point that I'll point out to you is we will give our best legal answers for them here, but must acknowledge that these answers are debatable and uncertain. So your own Attorney General's office is telling us what? This law and their interpretation of this law is uncertain and unclear because the law was written that poorly. I'm trying to stress to you just how badly our legislature messed this up. And your safety, our safety as law enforcement is what hangs in the balance. One of the main things that they start talking about is what is the definition of force, physical force? Their law didn't define it. It's a huge issue. Let's go to the next slide. In light of this uncertainty, for the following reasons, we strongly urge the legislature to clarify its intent regarding these important questions. Pretty damning statement from the AG's office concerning their legislation. First, and he's absolutely right when he writes this part, these bills address profoundly important topics regarding policing and issues that can literally constitute matters of life and death. Consequently, legislative clarity in these areas is especially important. I can't stress that any better. These are the very things that we face on the street that are life and death decisions. How we act, how we handle high-stress situations, violent high-stress situations, are dictated by roughly 70 years of case law from the United States Supreme Court. Case law that we learn, and we learn to the level that we can carry those decisions out without going through major decision-making steps. We learn them to that degree. We learn what Terry means. Terry versus Ohio. Our ability to, if I'm driving down the street at 3 o'clock in the morning, I look over and I see somebody rattling the door of a business, that's usually what we call a clue. Might be something going on there. So what do? We pull into the parking lot. We make contact. 3 o'clock in the morning, somebody rattling a business door. Well, under Terry, we have the ability to make contact. And let's say that the individual decides, well, I don't want to talk to you, I'm just going to leave. No, we don't know what's going on here. We could detain them. And quite frankly, we could use force to detain a person. Let's say that we make contact. Sir, I'm going to pat you down for my safety and your safety. Terry gives me the ability to do that, to see if he has any weapons at 3 o'clock in the morning as he's rattling business doors. Sir, for my safety, your safety, until I figure this out, I'm going to put you in handcuffs. Gives me the ability to do that. And if nothing's going on, we release. But if you can't explain why you're rattling this door and I call the manager and he doesn't recognize your name, I think I just disrupted a potential burglary. These are the ways that we protect you at dark 30 while you're sleeping. We make contact with people that appear. Terry says I have to have a reasonable suspicion that you are about to or in the process of committing a crime before I can make contact with you. And our legislature last year took that ability away from us in this respect. I can still roll up, I can still make contact, but if I say, sir, I need to talk to you, and you say, no, you don't, and start walking away, I have to let you walk away now. I have to let you walk away. What's bad about that, Sheriff? Well, let's say I let you walk away, I check the business, and lo and behold, around the back, there's a broken window into the business. I take a look inside the business and I find your employee tied up or dead. And that's happened here. That's not far-fetched, folks. That has literally happened in our area. We've had people break in to businesses late at night, early in the morning, tie up employees. We've had them kill employees. And under this new scenario, I just let that person walk away. I didn't identify them because I can't. I couldn't hold him there to make sure that your business was safe and your employees were safe. Couldn't do it under these new guidelines. Next slide. Here's one of the most amazing statements that came out of the AG's opinion. We cannot provide definitive folks. They cannot provide that definitive guidance to law enforcement or the public about the meaning of this important legislation. Can you imagine being in the legislature after you pass this to have the AG make the statement that they can't advise law enforcement how to interpret your legislation? Kind of flies in the face of everything that was put out in the media, by the activists, and by certain legislators, even in our area, that we were just whining, that we were misrepresenting the effects. When I say we, chiefs and sheriffs, when the AG says, no, this is so convoluted that we cannot give definitive guidance to the very people that need it the most, your law enforcement and the public, as to what these new laws mean. He goes on to state that even with this opinion from the AG, it doesn't carry the weight that your legislative words do, and the courts always give less deference, less weight to what the AG says versus the way the legislation is actually written. So this is not a great thing for us. He's basically saying, yeah, we can give you an opinion, but the courts don't have to follow our opinion. They will follow what they view your intent was. Next slide. So when can force be used under the new law? It says we can use force when we have probable cause to arrest, which is vastly different than reasonable suspicion, like we just discussed in the Terry stop scenario. It means I literally have to have probable cause. I have the right to arrest you before I can ever use force. Or to effect an arrest, that means that I already have probable cause. I'm going to make an arrest. You're resisting, I can use force. To prevent an escape, or to protect about imminent threat of bodily injury to the peace officer, another person, or the person against whom the force is being used. Imminent is a key word there. They really didn't define imminent all that well either. But imminent in the way that it's been interpreted means this. You literally have to be basically pointing a gun at us before we can use force. By that time, it's kind of late. By that time, the citizen or the police officer, I'm saying citizen, I'm not saying suspect, the individual holding the gun is not the victim, folks. The individual holding the gun, pointing it at a police officer or a member of the public, contrary to what the activists and certain legislators want you to believe, is not the victim. They're a suspect that's threatening the safety of the community. But if you listen to them, that suspect who's pointing that gun is the victim if they get shot. No, he was a suspect. He was an offender. He was a criminal. All words that our Marxist friends in the progressive arm of the party over there all want to say are bad. We shouldn't use those. Well, that's what they are. They are criminals pointing guns at people. Next slide. The AG made it very clear. 1310 does not define physical force, which is critical for a police officer to understand how to do their job. Critical. Absolutely bar none. Next slide. What is physical force? The AG spends about the next 5 to 8 pages of this analysis on what physical force means. And, you know, Webster Dictionary states that any violent action against a person's body, such as striking a person, would clearly qualify. But force also includes compulsion and constraint. What does that mean, Sheriff? Compulsion and constraint. The mere fact that I'm wearing a uniform can be seen as forcing you, compelling you to act the way I tell you to. And they say that that is force. And technically it is. My mere presence in the continuum of force, my presence is the lowest level of force. My words are the next level of force. So force isn't just hands-on, as we'll find in the next slide. Because they talk about the other side of the spectrum, which is unlikely to be satisfied by the merest touching. So, I mean, the AG went into great detail. However, efforts to render aid in some circumstances may cross over to physical force where the individuals are resisting and officers continue their efforts to force them into positions or situations they do not want to be in. What does that mean? Think about any mental health situation we run into on the street. The person that we are dealing with is mentally ill, he's compromised, but he or she is so compromised she's not following or he's not following our commands. Under this law, we can't put hands on. And that person may be getting ready to, do something bad, but it's not imminent. Remember, I covered that word imminent. I told you it was important. If it's not imminent, we can't take action. We can't use force. We have to obey the 4 guidelines that we showed you earlier. Next slide. The AG points out that between the 2 extremes we just covered is a large gray area. And he also points out that, but legislative clarification of this area or of this issue would be helpful. Goes on, always, because interactions between officers and the public generally always involve a degree of power or constraint, given that officers are endued with a great deal of authority, someone may appear to consent to be handcuffed without and not be resisting. What does that mean? It goes back to that Terry stop I told you about, where I can go under the old rules, sir, I'm going to put you in handcuffs for our safety. I'm not using force, you're complying. No force was used other than put the handcuffs on you. What it's saying is, no, my mere asking that is force. Next slide. These factors make us very uncertain as to what the legislature intended. All right. As to the situations where persons seem to be consent to being constrained by law enforcement officers, without legislative articulation of where a different line should be drawn, we believe force should be given its plain meaning. So this is what they finally come up with. Here's what we're going to say force is. And as a practical matter, while less violent forms of force are less likely to cause harm, they might still cause harm in some context. Next slide. So, the AG says, what is force? We acknowledge the uncertainty of this conclusion, and we urge the legislature to clarify the intent. I put that up as a title because I wanted to highlight that. Because what the AG said about force, we conclude that physical force means an act by a police officer that involves violence, compulsion, or constraint exerted upon or against a person's body. This includes physical interactions meant to restrain, hold back, and or control individuals, even if it is unlikely to cause pain or injury. But we acknowledge that the uncertainty of this conclusion, and we urge the legislature to clarify its intent given the importance of these issues. They made it very clear here, the legislature was not clear in what they wrote, and therefore there was no way law enforcement or you, the public, could figure out what this law had to say. Next slide. Next question that they asked was, does the standard in E2 HB 1310, I should say, preclude an officer from using physical force in the context of an investigatory stop, detention, based on reasonable suspicion and not on probable cause, when it becomes apparent that an individual will not otherwise comply with the request to stop. We've covered this. This is the Terry situation. Go to the next slide. Next one. One of the things that people in the legislature stated during a Terry stop, if somebody didn't stop for us, we could arrest them for obstruction. Therefore, we would have probable cause to use force against them. Well, the AG said, not so fast. Obstruction is very narrowly, and it is in the state of Washington, defined by the courts. The courts have basically said that unless somebody's going full physical with you, you cannot cite them for obstruction. So merely walking away from you is not obstruction. Therefore, they can walk away from you, it's not obstruction, and you cannot use force to stop them. That's what all that had to say. Next. One of the big things that came out of this legislation, and one of the crisis points that this legislation caused, was in the area of mental health. Even though courts can sign declarations saying that we will go and take somebody into custody for mental health reasons, 1310 really stopped that ability because we can't use force. Again, unless they're imminently in danger, we can't use force. Therefore, if they remotely say no or struggle, we can't use force to stop that. And this has caused major shockwaves throughout the mental health community. Frontier Behavioral is working with the legislature trying to get this fixed because it has damaged our ability to help people with mental illness. That it has damaged our ability to help people with mental illness. And the bottom line for the AG, the very short answer is, our answer to your second question largely dictates the discussion they had about the Terry stop. They concluded that the statutes you ask about here provide no independent basis to use force. So no, we can't. Even with the court's order to do something, we cannot use force to comply with that order. Next slide. I'm just highlighting what it said, folks. It provides no independent basis. So therefore, we cannot help people that are in the most severe need. The AG stated that our conclusion that these other statutes provide no independent basis for using force appears to better align with the intent of 1310 than would an alternative reading. So they said, no, 1310 said, you can't use force to do these things. Next slide. So how did the AG get where they got? How did they get there? Well, testimony like the one listed above from Mr., or I think it's Miss Daria Farvia, who is the disability rights representative for the state of Washington, testified that, I'm just going to read the most salient part. I cannot recall an incident where a victim, keyword victim, because in 9 times out of 10 they're not victims, they were suspects, did not identify as having a disability or display behavior during the interaction that suggested a mental health issue. I'd like to know where this individual lives, because I can tell you many times that I've faced down guns, knives, and other instruments, and the individual was not having a mental issue. They were not compromised in any way. They were just criminals. They were mean. They wanted to hurt people. That's what it was all about. So, but that's the type of testimony that ended up getting heard rather than testimony from your law enforcement professionals. They literally froze us out, folks, and they let this type of testimony in. Another reason the AG ruled or gave the opinion that he did on 1310 was the legislature had a chance to fix this. There was an amendment that was authored by Senator Holy out of the 6th here in Spokane, but it was not put in. And the AG states this, further, the legislature rejected an amendment that would have authorized peace officers to use physical force when necessary to act in community caretaking capacities, that's as in the mental health issues we've been talking about, and act when authorized pursuant to the chapters listed there, which are your mental health chapters and your chapters of being able to take people into custody under court orders. But they rejected it. They rejected Senator Holy's amendment. So this was intentional on their part. And that's why the AG made the rulings he made. You intended us not to be able to do this. Why did they do that? Well, because activists have been screaming, and the media has been portraying for the last 8 years, since 2014, August of, starting in Ferguson, that all law enforcement ever does is roll in and shoot people. That's what the activists and some of these activist legislature tell you, and the media has been more than happy to spread that all we ever do is show up and shoot people. We show up and escalate things. That's the type of testimony that passed this law. Well, when are we going to use the science behind law enforcement and the way we engage and the way we do our business? Because there's 70 years of studies out there, folks, 50 definitive years of research on it. And what it says is, in the United States, your law enforcement uses force very rarely, and excessive use of force is used to the level of being statistically insignificant, meaning it happens very rarely. Far cry from what they are portraying as, all we ever do is roll in and kill people. That's the nuts and bolts of how we ended up here today. That's the message that you've been fed. When are you going to start pushing back on that message because you know it's intrinsically, you know it is not true? When do you push back on the media? When do you quit rewarding the media for putting this out? How do we reward them? Because I say it's it's society's problem. We created this because we buy their products. We watch their shows. We do all that stuff. Maybe when we stop, maybe they'll stop. Next slide. The AG stated that our reading that Bill 1310 limits the use of force when taking individuals into custody under civil statutes you asked about best furthers the statute's overarching goal of preserving and protecting lives. I wonder how many lives in the state of Washington were lost because of this legislation this year because we could not act. How many people with mental health issues lost their lives because of this legislation? Be an interesting study. Next slide. So, the AG states this in his conclusion. To conclude, while the answer is uncertain, we believe the better reading of the statute is that officers may not use physical force unless authorized under one of the 4 permissible grounds in Bill 1310. You have to just shake your head when you read that sentence. While the answer is uncertain, the AG spent 26 pages explaining this stuff and still comes out, we are uncertain with what the intent of your legislation was. How can that be? 6 months of studying this legislation, 26 pages to digest that legislation, and we still come up with, it's uncertain what you meant. Please clarify. Do something to fix this. Perhaps you should have listened or at least brought law enforcement professionals, people that actually have degrees in the matter, and helped you write this legislation. Reform? I'm all about reform. We can always do better. But this was not reform. This was basically Independence Day for criminals. And that's the best way I can put it. Next slide. So, the AG says, we trust that the foregoing will be useful to you. I don't know about that. When you give me the answers to all your questions are extremely difficult. Our best legal answers for them here, but must acknowledge that these answers are debatable and uncertain. To state that these bills address profoundly important topics regarding policing and issues that can literally constitute life and death, and you're talking that we're still uncertain. In light of this uncertainty, for the following reasons, we strongly urge the legislature to clarify the intent regarding these important questions. Next slide. Well, the only way I can see this as being helpful was this. It only shows that sheriffs and chiefs were not throwing a tantrum. We weren't misleading the public. We weren't lying to the public. We weren't racist or white supremacist in stating that this law was unclear and dangerous to the public and to our peace officers. That's what this was really useful in, because it wasn't useful in telling me how to do my job in reference to this new law. It left us with uncertainty. What it left us with is sergeants in my agency going, folks, I don't know what to tell you. I would just let them go. And these are criminals, folks. We had an individual out in the valley, I believe it was 13 businesses they hit, hundreds of thousands of dollars worth of damage. Deputies are closing in on them. They get into a vehicle and the deputies had to let them drive away. Who won that one? The criminal. Like I said, Independence Day for criminals. Deputies were furious that they could not stop that offender, that criminal. They had to let him drive away. It's my hope that our legislature will take the AG's opinion to heart and fix what they broke last year. There's a bill out there, Senate Bill 1519, that hopefully will do that. But it only gets fixed if you, the citizen, start making phone calls. In the Spokane area, 12 out of your 15 representatives want it fixed. There are 3 that you need to call and express your concerns to, because they actually supported these reforms. That would be Senator Andy Billig out of the 3rd, Representative Marcus Riccelli out of the 3rd, and Representative Tim Ormsby out of the 3rd. Those are the 3 that you need to get on the phone with and tell them to pass the legislation to fix this. Folks, I get asked all the time anymore, Sheriff, how do we fix this? How do we stop this crime? How do we get our society back? Well, 1, you can't keep electing people that cause the problems. 2, in order to do that, you have to vote in your primaries and quit electing extremists, left or right. Elect people with integrity. People with integrity, even if they don't really have the experience, they'll learn the experience. At least you can know you can trust them. And George Washington would tell you that is the most important qualifying factor for somebody that wants to lead the nation at any level: integrity. We did this to ourselves, folks. You can sit and be Eeyore about things. Well, we can't change anything. Our vote doesn't matter. Or you can step up and do what's right. I will tell you that this right here is much more powerful than the thing on my hip. This can change the world by simply putting it on a piece of paper, filling in a dot, and voting for the right people. You want crime stopped? Don't elect those who are causing it or actually allowing it to happen. And that's what we have going on. Something to think about. Have a good day.
Thanks for watching. Ask the host a question, recommend a guest, or check out any of our other programs on Facebook, YouTube, Twitter, Apple Podcasts, Spotify, or SpokaneTalksMedia.com. Sponsored by River Ridge Hardware.